The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have three cases on for argument this morning. The first one is 24-1416, Finn versus Humane Society of the United States. Mr. Collins.
Good morning, Your Honors. May it please the Court. I am here representing two individuals who were former employees of the Humane Society of the United States, now with a slightly different name. I'm sure my opposing counsel will explain that, but they both filed for exemptions from the COVID vaccine. You're obviously familiar with the background on this, in that this case was held in abeyance pending the Barnett decision, which came out in January. And so you have asked us for supplemental briefing as it relates to the differences between this case and the Barnett case. And so I suppose I need to kind of address the specifics of each individual plaintiff as to what they did and why they filed their exemption request. Ms. Finn signed, and I think they both signed, a Humane Society form that attested to their sincerity and their beliefs.
Pretty straightforward case, isn't it? At least from that perspective. The question is whether it meets the religiosity test. And in this instance, you do have the benefit of this case that was not there for this district court judge. And from your perspective, for 12B6, that's where we are, isn't it?
That's exactly right.
That is sufficient for pleading purposes, particularly when you're dealing with religion.
I couldn't agree with you more, Your Honor, and quite honestly, I actually, after the Barnett decision came out, I fully expected that this just to be reversed and remanded.
Well, can I actually ask you a question?
Certainly.
And it goes to one of the plaintiffs, to I think it's Ms. Finn, is that right?
Yes.
So in Barnett, we said that it was sufficient to plead first that your belief is an essential part of religious faith, but also that it is plausibly connected, your religious belief has some connection or nexus to your objection to the shot. And I couldn't tell from Ms. Finn's statement, I understand that she has a religious belief in the sanctity of her conscience, but she never says what conscientious belief is in conflict with the workplace regulation here. Where is the conflict?
Your Honor, first off, I would hearken back to the decision, I think it's Passarella.
Well, I guess before you cite a case, do you know the answer to that question? What is the nature of the objection to the shot?
The reason I bring that case up is because what you're really dealing with here is how well does somebody have to plead to the employer as if they were in court. In Passarella, they made it clear you don't need to.
So you're talking to someone. I have a conscientious objection to working in this factory, and the objection is I'm a pacifist, they make armaments. Like, there's supposed to be a conflict there.
Well, clearly. And so she is talking about her conscience, okay? She talked about her faith in God.
Understood.
She talked about Father and Son,
belief.
Jesus.
I am not doubting the religiosity of her belief. I am asking you, how does that belief connect to her objection to this shot?
She based it on all of those things and used her conscience to reach the conclusion that this would be immoral for her to do. Now, morality is you can be moral and not religious. I get that. But clearly, when you are religious and you form a moral decision, which is what she did, that's clearly, when you talk about your conscience, you're making a moral decision, and you are reaching a conclusion. And what this lower court said...
So you feel, I mean, that is not how I read Barnett, but your understanding of Barnett is that if I come in and say, I have a religious objection to workplace requirement X, we're done here. I don't have to explain the nature, you know, what it is I object to about working in this particular factory. We're done.
Well, I always, you know, when I was studying for the SATs, they said never do the nevers and the always, okay? But, so I'm going to object to having to answer it in the absolute. So obviously, on the fringes, maybe there's something. But I will say
why
that
is that a fringe case?
Well, you're asking, you know, would you always be able to do that? No, what I'm saying here is under these facts, clearly, people, including her, had religious objection to this. This is not even fringe. There were millions of Americans that had religious objections to the use of these vaccines.
And in every case I could find, they said what the objection was. They said, my body is a temple, and that's why I can't put something in it. Or they said, these vaccines were tested on stem cells, and that's where the point of conflict is. And I would say, I have a very practical concern about this because, and I think you say this in your brief, under Title VII, once you get an exemption request like this, that's supposed to start a dialogue, and the employer is supposed to see if there's another way they can accommodate the objection. But if you don't know what the objection is, how is the employer supposed to do that?
Well, the objection here was clearly to not take the vaccine. The objection was to the vaccine itself. The law does not, and the Supreme Court has not required people to explicate the religious dogma that teaches them...
No, that's not what I'm asking. It's a religious belief. Let's take it out of the vaccine, because maybe what you're saying is it ought to be obvious. Everyone should be able to figure it out. So let's make it one that's less obvious. I can't work in this factory because I have a religious objection. What's the employer supposed to do to see if they can accommodate my objection? I won't say what it is. I won't say what the point of conflict is.
That situation is not this. That situation is, I can't work here, I'm not going to tell you why.
That's what this is. I can't get the shot, but I won't tell you why. All I will tell you is I have a conscientious objection.
Well, so let me go back to the term conscience, okay, and conscientious objection. She said that this would betray her conscience, and she referred to the Catholic bishops and the Pope's encyclical on that, and that it was written on her heart. Those are all terms that are used throughout the case law, which, by the way, is consistent throughout the jurisdiction, throughout the various circuits, okay? That conscience itself, and when you refer, I mean, she clearly is Catholic, she's referring to the Pope's encyclical, she's referring to the fact that she does not think that this was moral for her to do. And when a person...
that Judge Harris is posing is really a question that asks you, what is the limiting principle here?
Okay.
In other words, when you say, my conscience and heart are guided by something, where is the limit on that?
Okay, and that's an excellent...
That's the point that's made in the cases we look at Barnett. And the trial judge here didn't have the benefit of the Barnett case, of course, and focused on the fact that you did not, as you say, look at the dogma, call out Catholic or that sort of thing. Those things have within it the religious aspect of seeing it directly. I submit you probably won't run into this again, because I'm pretty sure the next time this comes up, it will be said differently, perhaps by the person that's doing it, in terms of as we begin to delineate how it should be said. But in writing such an opinion here, where the basis is, my conscience and heart are guided by it, what is the limiting principle?
What I would suggest to you in that, Your Honor, is that's really no different than saying, I prayed to God, and from that prayer, I have reached the conclusion that I can't do this thing. All right, so prayer. Do you believe in prayer? Some people don't believe in prayer. A lot of people do believe in prayer, as did the founders of our country and the people that wrote Title VII.
I mean, when you get into the examples, of course, you can always pick them apart and do things. That's not the aim here. The aim here is focus on even the prayer itself. Does that mean that you can get on your knees and say a prayer, and now I don't have to do it because I prayed about it? That's not exactly what we probably look at as being fulfilling of the religiosity requirement.
That's where I was
So
going
the
with that.
Specifics, somewhere in between here, we're trying to work that. And I think that was the purpose in Barnett, to move to a place where we can identify this individual. Again, we're on 12B6 now, so I think that might sway a little bit more in terms of the pleading of it. And whether you survive on summary judgment might be another question, or even beyond there, but we are there. But the limiting principle is really what we're focusing on.
Well, that's what I was heading to, Your Honor, was the fact that, number one, there were interviews also done after she submitted it. So those are part of the facts, not the record yet, because we're at 12B6. But those are part of it. There were 2 interviews done of this individual where she was able to discuss this with them. That's number one. But if you're asking for a limiting principle, what I was about to...
What she said? I'm just genuinely curious.
Pardon me?
What did she say? What was her objection to getting
Her
the
deposition
shot?
has not been taken, and I don't have a specific quote to give you. And certainly, that's one of the things that will happen in this case when you remand, if you remand,
Well, but don't we
is
have to
that...
rely, excuse me, I'm sorry, Mr. Collins, don't we have to rely on the complaint?
Exactly.
And the statement made by Ms. Finn? So that's what we need to focus on. Depositions come later, and, back to Judge Harris's question, what is it about Ms. Finn's statements that put her closer to the category of Ms. Muldoon's statements, or the ones that we thought were appropriate in Barnett?
Your Honor, I made a list of Chinnery, Finn, Muldoon, and Barnett, and of what the words were that they used. And the similarity in the words that they were using is amazing. I mean, they all used very, very similar language in expressing themselves on this. And that's why I brought up that Passarella case, because we're not talking about lawyers pleading things. Yes, the complaint is there. I believe I have alleged it clearly in the complaint under 12B6, that it was because of her religious beliefs and her sincere religious beliefs that she could not do that. If you're going to focus only on the one document, which is the one thing that they both submitted to HSUS, that's a bit of a different thing, and that is where Passarella comes in. But if you're talking about this limiting principle, what I would suggest is that the limiting principle comes in at the next step, because Title VII has 2 extremely important limiting principles. One is undue burden, okay? The other is sincerity. If they can show she was insincere, they can win this. If they can show that that they have an undue burden, they can get past this. One of the things that the lower court used was this creates a blanket privilege. There will be chaos in the workplace, as if there would be chaos in the workplace. And that simply is not the case. It certainly is not borne out by what's happened since then, but more importantly, it just doesn't even make sense under Title VII. The limiting principle comes on the sincerity aspect, because people can believe all sorts of things that you don't understand and you don't agree with, and you would come to a different conclusion if you were to get on your knees and pray, if you were to exercise your conscience, if you were to read the Pope's encyclical and reach a different conclusion.
Principles, so, I mean, it's funny because this case almost seems like it's from a different era. What if I want a COVID vaccine and I'm not in an FDA recommended category? Can I guess I'd be under the free exercise clause, but same idea. Can I get one by saying my conscience is my God and my conscience tells me the FDA needs to make an exemption and give me a COVID shot?
I believe that that there is case law, Your Honor, that deals with unapproved drugs and says no to that.
Well, it's being approved for some people. And
Pardon me?
But so you would say I have sufficiently pled my entitlement to an exemption, and they would have to say there's a compelling interest.
I don't remember the exact standard on this. I know that this issue has been argued, and
It has already? That was fast. Who argued it?
well, I've seen it in briefs on this topic, exactly that
Really?
issue.
To
and
get the COVID
that
shot?
argument was being used on the other side, saying, wait a minute, what if I wanted to do that? And what the courts have said is that we don't have a constitutional right to take a drug. So if a drug is taken off the market,
But
for
it's
example.
on the market. I feel
Oh,
like
if it's
I
on
can-
the market?
Well, it is. If I'm over 65, I can get it. If I'm physically inactive, I can get it. I feel like I have a really good case.
Oh, you're talking about somebody who...
I'm talking literally about the COVID vaccine.
And somebody
I'm
is not eligible for it. I believe what the courts have said, and I have not briefed this, Your Honor, but I believe what I've seen in other briefs that I have read, they've argued that the FDA, that nobody can claim a constitutional right to something that the FDA has prohibited. That's what I read. I don't think
But you
that
think I
is
would have, like,
dispositive
my-
of this issue. Pardon me?
Right, but you think I have gotten past sort of the first step. I have sufficiently pled a substantial burden on my religious beliefs, and then they're going to say, well, there's a compelling interest in not giving it to you because you're 2 years too young.
I believe that would be
Okay.
the analysis, Your Honor. That makes sense to me. But I think we really have different facts here. And I would urge you to do one thing, and that is to compare the expression that was used by the four different plaintiffs, and that we're talking about: Chinnery, Barnett, Finn, and Muldoon, and they are amazingly similar. Thank you very much, and I'll reserve my last 5 minutes. Thank you.
Thank you, Mr. Collins.
Good morning, Judge Nguyen, Judge Diaz, Judge Harris. May it please the court. My name is Leslie Maffio. I am here on behalf of the Humane Society of the United States, recently renamed Humane World for Animals, and here to ask you to affirm the April 24, 2024 decision of the District Court of Maryland in this case. We've already discussed what happened in Barnett. Thereafter, there was the Chinnery case, and Judge Nguyen, I believe you sat on the Chinnery panel. And in that case, the decision of the district court was vacated and remanded so that the district court could decide that case, based on the guidance coming from Barnett. In Chinnery, this court dispensed with oral argument, and that didn't happen here. So you want to hear oral argument here, you want to hear from Mr. Collins, you want to hear from me, and I believe that's because you see how this case is different. In Barnett, quoting a 1965 U.S. Supreme Court case, United States versus Seeger, this court clarified the test for maintaining a Title VII claim based on a failure to...
Why isn't it enough on 12b-6 for the claimant to simply indicate that they themselves characterize themselves as religious? Why is that not enough for pleading purposes?
Well, I think, there's a two-pronged test, that the belief is sincerely held and religious in nature. There is a second prong there. It seems not worth having a prong at all if all you have to do is say, my belief is religious. It's a light burden, clearly. In Barnett, in Seeger, the Supreme Court stated, courts are not free to reject beliefs because they consider them incomprehensible. Rather, their task is to decide whether the beliefs professed are sincerely held and whether they are, in his own scheme of things, religious.
Counsel, can I ask, sorry to interrupt you, so I think you may have garnered from the questions that we asked Mr. Collins that there might be some skepticism about Ms. Finn's assertions and the connection between her religious beliefs and the reason why she couldn't or wouldn't take the COVID vaccine. But what about Ms. Muldoon? I mean, it seems like Ms. Muldoon's statements are fairly well tracked. What we said was sufficient in Barnett. Are you suggesting that she, in light of Barnett, has not met the test either?
I do think that,
Why is that?
Muldoon has not met the test. First of all, both of these women, to me, very blatantly skirt around the issue of religion. I found it interesting that Mr. Collins said just a few minutes ago that Ms. Finn is obviously Catholic. But I don't think that was obvious at all
Well,
from
do
what
they
she
need to
said.
identify a particular sect in order to satisfy the test? I don't really.
No,
Yeah.
absolutely
So
not.
why does that matter?
Absolutely not. I just thought it was interesting that he said
It
she
may
was
be
obviously
interesting, but
Catholic.
it's not relevant, so.
Well, I think what's relevant is both of their requests very much feel like, you know, hey, I don't want to blatantly lie, but I want to make this sound like a religious objection.
Well,
So
that
they
gets
kind of
the-
throw
that-
in,
yeah, well, that gets perhaps to the sincerity of a particular plaintiff's beliefs, but that's a different issue.
absolutely, and I understand sincerity is not an appropriate topic at the 12B6 stage. But I think with respect to Ms. Muldoon,
You have a hard burden in that one. This reads that it would compromise her religious beliefs founded in my Christian upbringing that fetuses are individuals. She's saying that's being used to make the vaccine, and she did not want consent to use her body for this. That's a hard one. Do you really want to walk that one and with your time up here? I mean, maybe it's convincing to some extent, but I'm looking at it. That looks hard to me.
well, how often, I would ask, do you hear people talk about their religious upbringing but to explain changed circumstances
This is
now,
very pointed.
right?
She says, my religious beliefs here, and she's dealing with that fetuses are individuals, and you use the fetus to make this vaccine. I don't want you to take this vaccine. But you want to keep arguing. So go ahead. I mean,
I
don't
don't need to.
care.
I think you're very clearly telling me not to bother
No, I
with
did
Ms.
not. I
Muldoon.
mean, from my perspective, it looks pretty clear to me. But Finn, seems like you can spend a little time on that. But I know Judge Diaz wanted to hear that too, and I do too, want to hear. Go ahead and articulate your position on it.
I just think with Ms.
I said that so
Muldoon.
you'll know where I'm coming from. So now work with that and work me away from it.
Absolutely. I just think when, you know, I think you can be opposed to abortion without that being a religious belief. And I think Ms. Muldoon attempts to make this sound religious by talking about her Christian upbringing. The only time I hear people talk about their religious upbringing is to say, oh, well, I was raised Catholic, but I'm an atheist now. Or I was raised Baptist, but I converted to Judaism when I married my husband. I never hear people talk about their Christian upbringing, but to say that something is different now. And Ms. Muldoon didn't say anything about any religious beliefs she currently holds. She talked about religious beliefs that were founded in her upbringing. Basically, my parents were Christian, and they said abortion is wrong, and I believe that. But that doesn't necessarily make that a religious belief. So that's all I will say on Ms. Muldoon, because Judge Wynn, you at least have suggested you can't be convinced.
You might have convinced me to go the other way. You just keep going.
That's my point. Sorry, go
Can I
ahead.
ask you a question? I
Yes.
feel like there are two different ideas kind of bouncing around this case. One is whether the belief being asserted is sufficiently religious in nature, and that's what we were talking about in Barnett. But it's not a two-part test. It's kind of, I think it's more like 3 parts. We have said that we need a prima facie showing that you have a religious belief, and that has 2 parts, sincere and religious, that conflicts with an employment requirement. And as to Ms. Finn, at least, I would like to know which argument you are making. Is it that there is no religious belief, her belief is not religious enough, or is it that there is no conflict pled, a conflict between her religious belief and the requirement?
Both, and I think that's what the district court held as well, that she did not articulate any religious belief that was in conflict with the then applicable COVID vaccine mandate that the HSUS had at that time.
How much does she have to say? I mean, as she says, her heart, conscience, and faith in God and Jesus prevent her from complying with the mandate. Why? I mean, does she need to write another New Testament? I mean, what else does she need to say?
No, but I think she has to put the employer on notice of, a religious belief that conflicts with the requirement. It's the same thing with an ADA accommodation, right? We don't just, somebody doesn't come in and say, I need to work from 12 to 4 based on a disability, and then the question is immediately, well, let's see whether we can reasonably accommodate that or it's an undue burden. It's easier in the ADA case because we can have a doctor sort of go through much of that analysis for us and say, okay, is there a disability here that needs to be accommodated?
But this is Title VII, and the question is,
Right.
give us an example because in the way in which you're putting it, I'm having some trouble is what is going to meet the religiosity requirement. What's an example in using here? How would she say this differently?
Well, I think Barnett met I am not arguing that Barnett was wrongly decided. What I'm arguing is that you can take as true that Barnett was correctly decided and still make a different decision here.
So what would Finn have said that would meet that requirement?
I don't think Finn can meet that requirement.
She can't say that I have a religion and speak to something specific within the religion and indicate that is a basis for me not to.
Well, I suppose she could, but I don't think that that is her reality, or else I think she may have put it in her request.
And the difference with Finn and Barnett said,
Well, Barnett said that she is a devout Christian, and again, I'm not suggesting that you have to claim a specific religion to
got that, what did she say?
to meet that test. She said she was a devout Christian. She was baptized in 2011, and
Is
she
she there
makes.
yet with those two statements? So she's not there with those two statements, so what gets her there?
Well, she says that it would be sinful for her to engage with a product such as the vaccination after having been instructed by God to abstain from it.
So is that it?
Not in its entirety, I don't think. That her religious reasons for declining the COVID vaccinations were based on her study and understanding of the Bible and personally directed by the true and living God, not her conscience. She says this was directed by God. And finally, this court noted that she alleged that receiving the vaccine would be sinning against her body, which is a temple of God, and against God himself. This court decided that that was sufficient. I would say
it seems as though the Supreme Court has gone this way. I'm not in the business of guessing what the Supreme Court is going to do if this case were to get there, but it seems as though, at least in these cases, the pleading requirements have really been softened, lightened quite a bit, get you to the ultimate test of saying the prima facie case has been established. Then you turn to probably something that's more meaty, and that's the accommodation aspect of it. Why wouldn't we move more in that direction with these kind of cases to determine, well, can they be accommodated?
Because that's not what the law says. The law doesn't say somebody asks for a religious accommodation, see if you can
But don't you see
reasonably
the trend?
accommodate it.
Don't you see the trend with the Supreme Court and with Barnett? That seems to be the trend that's going in that direction. The court has a way of treating certain constitutional things differently and statutory things differently. I mean, we know that First Amendment, privacy rights and stuff, sort of treat a little different here. Don't you think that's what's going to happen here with this religious requirement here? In terms of what we've seen, I'm not asking you to guess, but it's right there in front of you. But don't you?
The tide
it's
has
basically pushing us to really probably get to certainly to get the summary judgment on it, not just the pleading. And then the question might become, even if you do meet the prima facie case, did you make any effort on accommodation? Which, in this instance, you don't get there because they never got to that aspect of it.
right. Trend, yes, I see a trend. The tide has turned on these cases with respect to Title VII, and it does appear as of late that the vast majority of courts have ruled that they met their burden at the 12b6 stage. But the burden hasn't been eliminated, which strongly supports my contention that it is possible to not meet that burden. It is possible, if there is a test to see whether somebody has met a certain burden, whether somebody has established a prima facie case, there has to be examples of somebody unable to establish a prima facie case, unable to meet that burden, unable to show that they have a religious belief that is in conflict with the workplace requirement.
You know, it seems like ultimately the way these things are gonna turn out, someone's gonna come up with a boilerplate list of what meets a religious requirement. And they're gonna read that and walk in the HR department and read that requirement. That's gonna take care of this, isn't it? I mean, it's almost nonsensical when you think about it, because it happens all the time. You give examples how to do things, and here they didn't use the magic words. And at the end of the day, very few of us were gonna leave saying, she really didn't try to talk about religion. She's talking about religion. She just didn't say it in the manner that you were saying it should be said. But it just seems like it is definitely a direction, if it hasn't already gone there, someone's gonna make a list of what meets the requirements, and you go there and you pull that piece of paper out and you read it. It's gonna meet it, it's gonna get them in court on a pleading requirement if you do something different, at least the prima facie case.
Well, and that to me is very telling here, that, I mean, there are already, I don't know that there's, you know, an exact list that has been, you know, sort of blessed by the U.S. Supreme Court. I mean, there isn't.
Well, I mean,
but
but the whole point of religion is that there's no one test. I mean, everybody comes to their faith or not.
Exactly.
Individually, right? And so, let me ask you about this statement in Ms. Finn's, the sentence in Ms. Finn's statement, where she points to an encyclical written by St. Paul VI that talks about conscience. And she says, she quotes it, she says, in all his activity, a man is bound to follow his conscience in order that, or a woman in this case, that he or she may come to God, the end and purpose of life. It follows that he is not to be forced to act in a manner contrary to his or her conscience. So essentially she's saying there that this encyclical, this religious tenet of the faith, although she doesn't say it's Catholic, but obviously St. Paul is a Catholic pope, leads her to a examination of her conscience, which is a significant part of the Catholic faith, to decide for yourself within limits, obviously, what your conscience says you should or should not do. And she comes to this conclusion that her conscience dictates that she not take the vaccine. That seems to me like faith, statement, consequence, result. It may not be as articulate as you may like it to be, but why is that not enough?
I just don't think it can be, because what it does is, and Mr. Collins addressed this briefly and pointed out that the sincerity and undue burden are sort of stopgaps on.
Well, they are, right? Ultimately, you can still challenge that. I get it. It's a step that you might not prefer to take if you can kick out the case at the 12b6 stage. But anyway, tell me why that isn't enough.
Well, the Passarella case was referenced by Mr. Collins. It was referenced in the Barnett case. Obviously, that's 108 F 4th 1005. Obviously, that case is not binding on this court, and even more so, Judge Rovner's dissent is obviously not binding on any court in any way. But this is one experienced, learned federal appellate court judge that I think had a very well-reasoned discussion of sort of a very similar fact pattern. There were also two plaintiffs in that case. With respect to Passarella, Judge Rovner states that Passarella emphasized that her conscience comes from God, that the Holy Spirit dwells within her, and that she is obligated to operate under her conscience, which is a God-given message. Thus, while the science states that we should receive the vaccine for various reasons, we need to lean on God's understanding that has been given to us through our conscience. Accepting any of the available COVID vaccines into my body would place my trust in man over my faith in God, which defiles his temple. Judge Rovner says, it cannot be enough to state a claim for a religious accommodation to assert that because one's conscience is God-given, any decision one reaches in their good conscience is necessarily inspired and endorsed by God and therefore is religious in nature.
That was a dissent.
I know. I'm just saying, I think it is a very well-reasoned position.
That did not win the day.
That is true.
Okay.
That is true. In the Seventh Circuit, it did not win the day.
Can I ask you a question? I mean,
yes.
we're talking about like lists and what people might say or not say. I mean, what if one of these claimants had just come in and said, I have a religious belief against this vaccine? Like, it seems to me that your problem is almost, your concern is that they said too much. If they had just come in and said, look, I have a belief that I consider to be religious and it is against getting this vaccine, would we, like, what about that? What would be the problem there?
I don't know that I can weigh in on that hypothetical.
Well, why not?
I think,
I mean, it seems like for you, these women get in trouble because they try to say more. But if you just say, I mean, I don't know the list is going to be so long, just say, I have a religious objection, period.
right. And maybe that would be different than what we have here. But here, to me, it seems to be a very clear attempt to skirt around the issue of religion, which to me suggests that it's not a religious objection at all. My time is up.
Thank you very much.
Thank you.
I would also like to thank you for having oral argument in this. We don't get this opportunity too often. But first off, with regard to the Chinnery issue about whether to remand and for a first look at whether or not this should be reconsidered by the lower court, I would suggest to you that this is not an appropriate case. That case was different because it was, as I understood it, was pro se. It was a per curiam decision, and here we have the pleadings. And sorry, I had to bring my joint appendix. And the pleadings are very strong. If you look at page JA09, they talk about Finn saying, my conscience and heart are guided by my faith in God the Father and His Son, Jesus Christ. The HSUS policy would unjustly force me to act in betrayal of my conscience and faith. That's in the complaint, and that is sufficient to get past a 12B6 motion. And I would refer you to also page JA16. Here, plaintiffs had bona fide religious beliefs that conflicted with HSUS COVID-19 vaccine mandate. Those are in the complaint and should be considered adequate under 12B6.
Can I ask you to just address the question I asked your colleague? If these claimants had come in and simply said, I have a religious objection.
And that goes back to your earlier question to me, and I wanted to get back to that as well. And that was about...
But could you start by
I will,
answering that?
absolutely.
Yeah, great.
And that is, I believe that actually would be enough, because then what happens? What happened here? You go back and you have your conversation. And that earlier question you asked me, what would happen if the person comes in and says, I can't work at this factory? Okay, so the employer then says, well, we've got 12 other factories in the area. Is there one that you can work at? Oh yeah, I can work at that one. And why can't you work here? Well, because at this factory, such and such. Okay, they explain themselves.
So
but
you
if the
think at
employer
some
says,
point, I'm sorry, so you think at some point the employee is going to have to explain what the conflict is, but not up front?
well, at some point they're going to have to say where the conflict is in terms of what they can or cannot do. For example, I had a Jewish employee. She had to leave Friday afternoons early to get home for Sabbath. we always let her go home early on Fridays and Sabbath, especially during the summer, because the sundown and so forth, or in the winter, excuse me, because of sundown. But, so they need to explain not the tenet of the religion, they need to explain the limitation on them. Here, she explained the limitation on her. Her limitation was, I can't get vaccinated, okay? And that is against my conscience.
But just imagine, I mean, I don't know that there were COVID vaccines available where some religious claimants did not believe they were tested with stem cells. But imagine there were. So this woman comes in and says, I can't get vaccinated, but she doesn't say why. And so the employer doesn't know, well, is there a vaccine out there I could give her, to which she wouldn't have an objection, because she never said what her objection was, whether it was about stem cells or not. Do you see, I'm just worried that.
Sure, I understand.
But I thought maybe for a minute there we were agreeing that at some point she is gonna have to say what the conflict is, but maybe not at this point.
I think it's also a question of granularity. How much detail? Does she have to cite the catechism? Should she have cited the catechism instead of an encyclical? Of course not.
I'm not looking for, I am 100% assuming it's a religious belief. There is no question that her belief, her conscientious objection comes from a religious source. I'm just saying, at what point does she have to tell the employer what the conflict is so that the employer can try to figure out whether it can be accommodated?
I think maybe we're talking past each other, because what I see as the conflict is the taking of the vaccine, or in your example, the working in that factory, or that sort of thing. And yes, she has to explain that. Now, if she comes back to the employer
Can I follow up on that? So with respect to Ms. Muldoon, she, I think, very specifically indicated the conflict was the fact that she believed that the vaccines included stem cells of aborted fetuses or fetuses, and that was the concern. So she fairly clearly explained why that was an issue. I guess Judge Harris's question is, does Ms. Finn have to do the same thing?
I was about to get to that example, exactly that example. And that would be when the conversation occurs, when you say, well, where is the conflict? You know, can we accommodate this conflict? Is there something we can do to keep you here? Yes, the employee has to engage in that process to try to figure out, is there a way to keep you here? Oh, wait a minute, there's a vaccine over here. Or will you mask? Will you socially distance? Will you test every day? Will you test every week? Those are all various things that could have been done, but were not offered to these employees. Will you continue to stay home and work at home? Remember, we're talking about people who were working at home. Before I lose out all my time, I did want to deal with the Chinnery case and why you shouldn't.
You're over your time right now.
Oh, I am over my time? Well, I just wanted to explain that I don't believe that this case is one that you should be sending back just for the judge to reconsider.
All right.
Thank you.
Thank you, sir. All right, thank you both for your arguments. We'll come down and greet you and move on to our second case.
This case is on a motion to dismiss. It's here because the district court granted the, I'm sorry, not a motion to dismiss, a motion for summary judgment. I'm so sorry. I got too caught up in the last argument, I guess. This case is whether or
You don't
not.
want to do that.
Huh?
This is a different case.
I know, I gotta clear my head. This case is about whether Sheppard Pratt violated Title VII when it refused to accommodate Ms. Hall's sincerely held religious objection to the COVID-19 vaccine and terminated her. The record is clear, she made her prima facie case. She had a sincerely held religious belief against the vaccination. The conflict was that by taking the vaccination, it would conflict with her religious beliefs. The requirement was that she take the vaccine in order to continue working, and she was terminated. The issues for this court to hear are whether Sheppard Pratt failed to engage in the accommodation process, whether they failed to accommodate her at all, and whether in doing so, they, or in not doing so, they proved that it would be undue hardship on their part. The main argument would be following Groff v. DeJoy, that an employer must show, and I read show to mean prove, that a substantial increased cost or burden would be borne in relation to its business if they accommodated this one request. We're not talking about how they would accommodate 20 requests, 50 requests, 3,000 requests.
I'm sorry, you got that out of Groff, that an employer can't aggregate the burden of granting all of it? Because I didn't see that in Groff.
I think that they can, in terms of relating if there were employee objections, if there were issues that were specific to that business, they might be able to. But the first step is, how does it impact this first individual? How can we accommodate this individual? And if it would be an undue burden to do so, then we don't have to.
But how do we escape not looking at the aggregate effect here? I mean, you've got numerous people who are seeking this exemption. How do you just focus on an individual in a setting such as this, where you're talking about patient health and safety?
And I think those are fact issues that should be determined by a jury rather than as a matter of law.
What evidence do you think is in the record that would allow a jury to find that granting an exemption to people comparably situated to your client who work face-to-face with especially frail patients and with other people who then work with those especially frail patients, what's the evidence in the record that that would not impose a very substantial safety risk in a hospital environment?
Again, with what the other side has cited is the generalized state of the world at that specific time.
Right, because like germ theory and everything.
Which we understood. But what Title VII requires you to do is to take a look at what are this person's duties and how can they be accommodated, or would any of those accommodations cause an undue burden? And I think Sheppard Pratt, the evidence shows that they jumped to, well, she's patient-facing. They didn't look at how long she was patient-facing. They didn't look at how they could redesign her job.
I thought they absolutely did. That like the first step was they consider whether it would be possible to do this job remotely, so that you wouldn't.
They considered whether they could do the job completely remotely, and the answer was the majority can be done remotely. There's a portion that can't.
Okay.
They didn't say, is there somebody else that can do that job, the non-remote job. So, and I think that's part of the discussion. How can we accommodate you? She wasn't a full-time worker, so if there was something that, you know, her hours needed to be cut a little bit, or there were other things that could have been considered that weren't. It was simply, the other thing that I want to make clear is that the record does not contrary to what the district court judge opined, the record does not show that she had substantial face-to-face interaction with patients. It's very much to the contrary. For 18 months up until the time that they said you need to be vaccinated or you're going to be fired, she practiced social distancing when she did those admissions. She did everything on the computer. She did the initial work on the computer, checking insurance on the computer, doing all of her job with the exception of the person who's going to be admitted into the hospital coming into the lobby and standing 6 or more feet away at a time when the lobby did not have anyone else, and it could be confidential, it could be quiet. She did her job with no issues. There's no record that supports that she infected anyone, that she caused any disruption in work, that her coworkers were concerned that because she wasn't vaccinated, she followed all of the CDC guidance in testing, masking, and social distancing.
I feel like you've got kind of an uphill climb, just given the way the case law has developed. It does seem that most courts of appeals have concluded that when it comes to people who work in hospitals and healthcare facilities, it really would have been an undue hardship to make exemptions. And some of those cases include, I know in the Sixth Circuit, and I'm blanking on the name, but it was a pharmacist, someone who had no direct contact with patients, but had direct contact with other people who then had direct contact with patients. And I mean, are there any cases in the healthcare context? Yeah.
Yes. There's one recent case out of the District of Maryland, actually, that survived summary judgment that is now moving on to trial. It is Anorou, A-N-O-R-O-U, v. MedStar. And in that case, the decision at summary judgment was that the medical facility had not proven that this person was a safety risk. They gave very generalized safety concerns.
What kind of job did the person have? I mean, I'll find the case, but I'm just curious.
In Anorou, I'm not sure that I have the information.
I'll find it, it's fine. Sorry, I don't want to hold you up.
That's okay.
That's a case that's in Maryland, you're saying right now, that's going in trial?
Yes, it was
For
decided.
which we ultimately may be reviewing to determine everything you're saying, whether or not it's correct. You think that's going to be helpful to us right now? I think if we say anything, it possibly could be picked up that we're commenting on that case. I don't think that's appropriate. Do you?
Oh, that if you say something about my case, that it will
The
somehow.
one that's down in Maryland that has survived summary judgment is now about to be tried, for which there may be likely an appeal to us,
Possibly.
possibly.
Well, it's going to a jury, so those questions that I'm saying to you that are fact questions that should be.
But that's not our case. We didn't say that. The district court said that. That has
No, but
no-
she was asking if there were any cases in the medical setting.
Well, I think that when we ask that, we're talking about appellate cases. Preferably our cases or the Supreme Court cases, or at least something from another circuit for guidance on it.
You are correct in that the consensus seems to be the bright line rule that if there is safety, if the defendant brings up safety as a concern, then it's an automatic, we don't have to accommodate you.
I didn't think the line was that bright. I did not think the rule was that bright line. I thought it was more in the context of a healthcare facility with vulnerable patients.
From all of the cases that I've read that have gone to the circuit courts there that deal with healthcare,
Yeah.
it's safety is the issue, and it becomes a bright line rule that if you're in the field of safety, it doesn't matter if you're a respiration therapist or an occupational therapist, if the entity determines that it would be an undue burden to accommodate you and they cite safety, then it's a bright line that you're not gonna you're not going to be accommodated, you're going to be terminated. And I think that's a dangerous thing to do, because it doesn't take into consideration the accommodation process. So it doesn't take into consideration what could she have done, what couldn't she have done, how could she have been accommodated, you know, where was that conversation? It's not in the record.
Did they offer her, I mean, I'm just sort of surprised to hear you emphasizing kind of the accommodation process and dialogue, because it honestly looked to me like this hospital had almost like a model policy, where first they consider, like, is it possible to do the job remotely, and if it's not, they invite people to transfer to a position that can be done remotely, and then they make really clear, look, if we ever change our policy, you're welcome to come back. Like, it seems like a pretty, what's missing from this?
What's missing on this is the practicality of it. On paper, it may look that way, but the question is, can you do the job remotely? And if it's not, you know, there was no question of how can we redesign this so that it can be done.
But, I mean, she's the admissions coordinator.
She
How
was
is-
one of the admissions coordinators.
Okay, but how does an admissions coordinator do the job if they're not there when the patients are admitted?
It would be a fact question for the, you know, during that deliberative process, of
But they
having a
had the
conversation.
process, and they concluded after their process, actually, we want the admissions coordinator to be there for admissions. So instead, we're gonna offer you the opportunity to transfer to another job where you don't have to be there. And she said no.
She applied for jobs or looked for jobs, and all of the jobs required the vaccination.
I thought it was in the record, but tell me if I'm wrong. I thought it was in the record that some people who had objections did transfer to other jobs that could be done remotely, and at that point, they got an exemption. But if that's not in the record, correct me.
The record, I'm not sure if that's fully in the record. The people who were granted the exemptions were people who were already working remotely. So they already had the model that they could be working remotely, which they hadn't tried in either a hybrid manner or any other manner for my client. And I think I'm just about out of time. So unless there are any other questions, I'll reserve the rest of my time for rebuttal.
Thank you, Ms. Kraft. Mr. Bergen?
Good morning, Your Honors. May it please the Court. Paul Bergen on behalf of Appalachia Sheppard Pratt Health System, Inc. I'm here today asking you to affirm the District Court's grant of summary judgment. Appellant was the admissions coordinator at Sheppard Pratt Health Center's Center for Eating Disorders. She had face-to-face contact with the hospital's most medically vulnerable patients and other employees who in turn had contact with those patients. The appellant was denied a religious exemption to Sheppard Pratt's COVID-19 vaccination policy, which was enacted following a state mandate and during a surge of cases due to the highly contagious Delta variant.
Were there any exemptions, religious or medical, that were in fact approved for the Center for Eating Disorders?
Your Honor, the Center for Eating Disorders did not approve any medical or religious exemptions. The general hospital system was able to approve some medical and religious exemptions under different factual circumstances and scenarios, but there were none approved at the Center for Eating Disorders.
So your client, Sheppard Pratt, makes a determination that affects patient health and safety. How do we, how do that evidence, or at least that statement, to what extent do we give deference there, or are required to give it a deference to that determination by a healthcare employer?
Yes, Your Honor. So at the time, given the state of the pandemic, the CDC guidance and data was overwhelmingly stating that transmission and infection of COVID-19 was heightened when it came to unvaccinated individuals. They were more likely to infect and transmit COVID-19. When it comes to Sheppard Pratt's determination for patient safety requirements, it looked at the scientific evidence available to it at the time regarding transmission and infection. It looked at the medical status of the individuals that it served, most of which are medically compromised and more susceptible to illness, severe illness and death from COVID-19. And it made a determination that it was obligated to put the health and safety of its patients first and foremost, and mitigating the risk as much as it was able to regarding the potential for infection on its hospital units.
Did the center have completely remote positions, and were those individuals also subjected to the vaccine requirement?
So, Your Honor, when it comes to the medical hospital as a whole, the 322-bed medical hospital, there were some individuals did work remotely. The remote individuals, if they could perform their position remotely, they were granted exemptions to, whether it was a medical or a religious exemption. The hospital also looked to see whether the essential functions, there might be an in-person position, but if there was a determination that the essential functions of the position could be performed remotely, then they would grant an exemption for remote work. I know of some instances where there were therapists, for example, who didn't have direct patient care insofar as they were injecting patients, taking vitals. It was more so talk therapy. And so that they permitted some of those individuals to perform the jobs remotely. Billing, people who were in the billing department, they might have worked in person, but those were functions that could be performed remotely. So there was a wholesome look at the job's duties, an individualized inquiry, and if the essential functions could be performed remotely, then accommodations were made. But if the essential functions were required to be performed in person, then they had to look at potential alternatives such as transfers and things of that nature.
Do you know the answer to Judge Harris's question about whether or not Ms. Hall was offered the opportunity to take on a remote position and she declined it?
Ms. Hall was offered the opportunity to search for remote positions that were able to accommodate her in an unvaccinated state. Ms. Hall did not apply to any or express any interest in any of the vacant positions at Sheppard Pratt, and nor has she reapplied for employment at Sheppard Pratt.
And her answer was she didn't do so because they required the vaccine.
Well, what she didn't do is she didn't inquire with regard to any particular position. Is this a position that can be performed remotely? The vaccine requirement applied system-wide, but to the extent that there was a position open that could have been performed remotely, she was more than welcome to express interest, reach out to recruiting, apply, but she declined to do so for any of the hospital's vacant positions.
Yeah, as I understand it, there were over 200 of these requests for this religious exemption, about 100 or so for the medical one. Does that affect the determination of whether there's an undue burden on the employer to any extent, as opposed to maybe you had one or two that were requesting it?
Yes, Your Honor. I believe the case law is very clear that an employer is permitted to look in the aggregate of the aggregate effects or the cumulative effects of granting any particular accommodation.
What case are you referring to?
I believe Hardison states that with regard to aggregate effects there. Hardison states that, the EEOC guidance states that, Together Employers versus Mass General Brigham, Inc., which is a District of Massachusetts case in 2021, which was affirmed by the First Circuit subsequently. There's some cases out of the District of Oregon, Lavelle Hayden versus Legacy Health as another example. But I would refer the court.
Anything in this circuit we've said that?
I don't know offhand, Your Honor.
Can I, just another question on this sort of aggregate effect. Do you need that to prevail? Or even if is it your position that the undue hardship here came from the aggregate effect? Or do you think it would have been an undue hardship just to grant this one exemption?
Your Honor, I don't believe that we need that to prevail. I believe the undue hardship came from granting this one exemption. The appellant worked face-to-face with the hospital's most medically vulnerable patients. The Center for Eating Disorder patients were often very medically compromised. Some of them arrived to the Center for Eating Disorders in ambulances, unable to walk. So these were medically compromised individuals who are more susceptible to severe illness and death due to COVID-19. I also think that it's important to note what happens if there is a positive case on any of these units. If there's a positive case on any of these units, then the unit has to go into outbreak status. And when the unit goes into outbreak status, the positive individual is put into a room of isolation. Isolation exacerbates eating disorders and mental health conditions, which are the very conditions that these individuals are going to Sheppard Pratt to receive treatment for. When a unit is also on outbreak protocol, communal and group activities cease. And in the mental health treatment context, communal and group activities are vital to the therapy that Sheppard Pratt renders. So a unit being on outbreak status significantly undermines the treatment that these individuals are coming, sometimes from across the country, to Sheppard Pratt to receive. Many of the individuals, especially those who voluntarily admit themselves to the Center for Eating Disorders, have failed treatment at numerous other facilities and come from across the country to Sheppard Pratt to obtain that treatment. And so when there's a positive case on the unit, not only do the patients suffer from the potential of the effects of the virus itself, but it also undermines the treatment and potentially exacerbates the conditions that they're seeking treatment for, which in and of itself is an undue hardship.
Can I ask you a question about what hardships we're supposed to be looking at here? This is a fairly unique circumstance, a pandemic, hopefully once in a generation, never to occur again, we hope. But the cases seem to focus, at least the cases pre-pandemic, focus primarily on financial costs to the employer, and there wasn't much evidence of what that cost would have been. Obviously, there would have been some cost, I suppose, in having to find someone to replace Ms. Hall during the time that she couldn't be there because of any accommodation that might have been given to her. But what about that? Is that a problem that those costs were not quantified? Do you need that in this case?
Sure, Your Honor. So I would say in this case, we don't need that. The courts have been clear that non-economic costs can be sufficient to constitute an undue burden, health and safety, reputational injury. But I would also say that while there were no quantifiable economic costs cited in the papers, there were economic costs associated with increased transmission of COVID-19, at Sheppard Pratt. One of which is when the center or any particular unit is on outbreak protocol, admissions to that particular unit cease. And so the hospital then can no longer admit patients. And so if beds are sitting empty, that's lost revenue to the hospital system. To the extent that there's increased transmission of COVID-19 that gets to employees, and the employees have to miss work at times, they had to rely on agency coverage, which is more expensive and an added cost. But I would say, Your Honor, that the non-economic costs associated with the potential accommodation were certainly sufficient to constitute an undue burden from the health and safety perspective and the potential reputational injury cited in our briefing.
She was in more of an administrative type position, wasn't she?
So many of her job functions, yes, could have been performed remotely. However, it was her...
My question deals with what she actually was doing. What kind of work was she doing?
So as the admissions coordinator, she walked prospective patients through every step of the admission process. So it started with the first phone call or outreach from a prospective patient. She would coordinate, insurance, coordinate any kind of
It seems to me, I don't know, maybe I seem to remember, it's not in the record, but maybe you remember, that individuals in that position, they sort of put them in a little glass sort of enclosure or something where you could do this. You could have a little opportunity to speak to a patient in front of you, actually in front of you, and deal with it. Was that sort of accommodation something that would have worked here for her?
No, Your Honor, that would not have worked. As an initial matter, there's no evidence that she worked also in person with other employees. So even if she is in a glass enclosure speaking with patients, there's no evidence that that would sufficiently mitigate the risk of transmission to those patients. But as she's traversing the hallways of the building in an unvaccinated state, that increases, it's an airborne illness, so that increases the risk of infection across the units. She shared a small office with another employee, a small 10 by 10 office. So those in-person contacts with coworkers, that is in and of itself sufficient to constitute an undue hardship. The CDC guidance and all the medical guidance available to Sheppard Pratt at that time indicated that it was vaccination that was the most effective infection control measure. Not masking and testing, not social distancing, not the erection of plexiglass or anything like that. The medical consensus was vaccination was the most effective measure. And to that end, her position, her in-person functions with these patients as the admissions coordinator, those were the most essential functions of her job, the actual admitting of the patients. This was not a job where the essential functions could have been performed remotely. While the bulk of her day may not have been spent doing this, just because a particular duty isn't performed necessarily for a significant percentage of time doesn't mean that it's not essential. The EEOC states that you need to look at the totality of circumstances when it comes to a particular accommodation, citing factors such as, is this job performed indoors or outdoors? Is it in a group work setting? Is there in-person contact with the public, employees, or medically vulnerable individuals? And here all of those boxes are checked. The appellant worked indoors in a congregate living facility. She had close in-person contact to patients, to employees. And I want to state that when it comes to employees, just because they weren't patients receiving care at the Center for Eating Disorders, we don't necessarily know what comorbidities other employees may have had. They may have had heart conditions, they may have had diabetes, they may have been receiving cancer treatment. And so those employees may themselves have been increasingly susceptible to severe illness or death from COVID-19. And they warranted, protection as well. Going back to the in-person functions of the position, the appellant established a rapport with these patients. Everything she did in the course of her job led up to the point of getting these patients through the doors admitted to the Center for Eating Disorders. Many were apprehensive about admission. Many struggle with anxiety. This is a monumental and life-changing decision for these individuals to voluntarily admit themselves for this treatment. So the appellant formed a personal bond with these patients, and it was her job upon their admission to in person greet them, get them in the building through the doors to receive the treatment that they need. She used the rapport that she had developed with them, sometimes over a course of months, to soothe those fears, to answer questions, to ease any potential anxieties. This is something that needed to be most effective to be performed in person with these individuals.
Ms. Kraft indicated, I think she said that there was more than one admissions coordinator. Is that right?
Yes, Your Honor. She did have a coworker, and it was the coworker who she shared the small office with. And
so would a reasonable accommodation have been to allow that coworker, I don't know if she also objected to the vaccine, but assuming she did not, to have her take up these primary responsibilities of interacting with patients and let Ms. Hall do the non-patient facing work?
No, Your Honor, and there's a couple reasons for that. One, it is an undue hardship in and of itself to alleviate an employee of the essential functions of their position and put those essential functions onto another employee. So this other employee, she had a full plate of job duties and responsibilities, and then to require her to do not only the in-person admissions that the appellant was doing, but there's also some legwork that's required for each admission, familiarizing oneself with the case. So that time burden in and of itself on this other individual would have constituted an undue hardship. The case law, I believe, is pretty clear that it is not a reasonable accommodation, and the employer is not required to eliminate a position's essential job functions. I'll also note that if the other admissions coordinator performed all of the admissions duties, that continuity that I mentioned earlier, that the admissions coordinator is with the patient from the first call, establishing that relationship over a course of months to then be the one there with them in person to greet them, that continuity no longer exists. And so these patients would be seeing a new face when they came to the Center for Eating Disorders for their admission. And that continuity was a vital part of the process. So I would say that these essential job functions could not have been adequately shifted to somebody else without constituting an undue hardship. And Your Honors, I would also like to say Sheppard Pratt engaged in a very fulsome interactive process. They evaluated each request individually. They had multiple meetings concerning each request. GROF requires the employer to evaluate whether other options are available for potential accommodations, and Sheppard Pratt discharged its duty under GROF. It engaged in a very thorough, wholesome, interactive process with every single individual who requested a religious exemption and a medical exemption. It evaluated other options. As I said, it evaluated remote work. It evaluated whether masking, testing, distancing would have been sufficient. It permitted employees to look for other vacant remote positions. It really, really went to great lengths to accommodate as many individuals as possible without compromising any patient safety. So it did engage in an interactive process and certainly did discharge its duty under Title VII and GROF in that regard. Your Honors, if you have nothing further, then I will rest on the papers.
Thank you very much.
Thank you.
Thank you. A couple of points on rebuttal. Nowhere in the record is there a full explanation that tracks with what opposing counsel has said her duties were: the hand-holding, the building a rapport, months and months of interaction with potential inpatient clients. So I'm not quite sure where that argument has come from and how that was an essential part of her job. The essential part of her job, as testified to during her deposition, was clearing insurance, talking to the referral doctor over the phone or over email, contacting, if it was a minor, the parents via email or by phone. If it was an adult, contacting the adult either by phone or by email. Keeping them updated on when a bed would be available. And then all of the documents and everything would have been signed beforehand, and then meeting them at the lobby to ask if they have any additional questions and to call the nurse to come get the patient for inpatient. I think that your questions raise really good points. it could have been possible to put up plexiglass and have her interact with the patients in that regard. She shared an
How
office.
would the plexiglass work?
Hmm?
How would the plexiglass work?
The same way that it would work at numerous of admissions offices that you go into the hospital now, where you go up and you have like a little cubby that you go into, and as the patient, and on the other side of the plexiglass is the,
So it's like a box, it's not just a divide. I mean, I remember when we had dividers, but you're not talking about a divider, you're talking
no,
about a box.
well, I don't know what exactly it would be, because again, it wasn't considered, but it could be a cubby, it could be a box, it could be dividers, it could be. The other thing that is important to know is that they only admitted maximum of 2 patients per day, and only on Tuesdays and Thursdays. They did not admit patients every week because it was a small floor. They had to wait for a bed to become available. And no 2 admissions happened at the same time.
So is the thrust of your argument that what went wrong here is they should have let her work remotely and then given her an exemption? Is that your argument? Or is your argument, because I didn't even get that from your brief. I thought the argument in your brief was she stood 6 feet away, what's the big deal? They should have let her not get the exemption and continue to work in person. But what is your argument?
I think that would have been one of the options, but remote work would have been an option. Any of the other safety precautions that were available
Right.
would have been an option.
Just let her wear a mask and do her job in person. I mean, did you argue? I feel like I'm hearing a different argument today, which is she could have done everything either in a box or remotely.
She could have done, we did make that argument, I believe, that she could have done things, that things could have been reworked, at least the discussion of how it would look, that didn't happen with her.
I'm sorry, so you did make the argument below. The mistake here was she should have been allowed to work remotely. She didn't really have to be there to greet the patients.
I don't think it was quite that clear,
Okay.
because the focus was on the fact that this was a blanket, you
Okay.
know, your job can't be done remotely. We're not gonna talk about whether or not it can be adjusted.
Well, I think she said in her deposition, I understand my job can't be done remotely.
She said in her deposition, I understand that it can't be done 100% remotely.
Okay. Can I ask you just another question to clarify the arguments that are in play? As I read your brief, you are challenging on appeal only on the failure to accommodate claim and not on the disparate treatment claim. Is that right?
Yes, we're
Okay.
addressing the failure to accommodate claim, the disparate treatment only to the extent that there were secular exemptions provided that were not provided for her.
Well, that is the disparate treatment claim. You feel you've argued that in your brief? Because I did not see it in your brief.
I believe that we did, but
Okay.
The only other argument that I wanted to make was the fact that the disruption to the hospital, again, this was a very small portion of the hospital. There's no evidence in the record that there ever was an outbreak of
Shoot, I'm sorry. Do you have your brief? Where would I find the disparate treatment argument?
I can provide that to you.
Oh, I have the brief. so-
Okay.
Okay.
I can pinpoint that to you in a 20.
It's all right.
Okay. Unless there are any other questions, I'll stand on the briefs.
All right, thank you, Ms. Kraft.
Okay.
All right, we'll come down and greet counsel and move on to our third and final case this morning. third case is 23-6245, United States versus Dimpka. Ms. Westover.
Morning, Your Honors. And may it please the court, my name is Blair Westover, and I represent the petitioner, Mr. Dimpka. I guess, as I view it, this case presents a fairly narrow question to the court, whether or not Ruhan versus United States constitutes a sufficiently novel Supreme Court case to forgive my client's procedural default when he failed to challenge his guilty plea on direct appeal. The test, I understand that, you know, just because, I think everyone acknowledges it would have been beyond futile for him to have challenged his guilty plea at the time that it was taken in 2019 under this court's case law. But I understand that futility and novelty are two different things. An argument can be futile and still be available. The test, however, there are cases where a Supreme Court case is sufficiently novel that it does justify finding cause to excuse procedural default. So there are three situations: where the Supreme Court explicitly overturns a prior precedent, where the Supreme Court overturns long-standing, widespread practice to which the court has not directly spoken, but which enjoys a near unanimous body of lower court authority.
Which of those three you think is the winner?
I'm going to try all of them.
Which one is your strong side?
I think it's probably three.
Yeah. That first one is kind of difficult, isn't it?
Well, here's my pitch. Before Ruhan, the decision was Moore, United States versus Moore. And I understand the government quotes Ruhan as saying Moore did not speak directly to the mens rea question.
That's true.
That is what it says. That quote is an accurate quote from the case. However, that was not the view of this court prior to Ruhan, nor was it the view of the majority of this court's sister circuits prior to Ruhan. In Allaire, in Hurwitz, in Trong, this court said, you know, this is an objective standard, and we're basing that on Moore, right? And if you look at the footnote in Moore, there's a good faith instruction that was given by the district court. And that good faith instruction looks a lot like the good faith instructions that were routinely upheld by this court and the majority of this court's sister circuits prior to Ruhan. So I think there is a sense in which Ruhan did overturn Moore, and it certainly overturned Moore in the way it ruled. Because Moore, you know, prior to Moore, so I will agree the central holding of Moore was that the CSA, the Controlled Substances Act, doesn't explicitly say, you know, this is the definition of medical practice and this is how practitioners are limited. So what Moore did is it incorporated the standard from the Harrison Act, which was the CSA's precursor as it applies to medical practitioners. That was all good faith. Good faith defined a doctor's liability. Ruhan, tossed out good faith entirely, right? It's like, we're not doing good faith anymore. We're basing this, we're saying knowledge of lack of authorization, right? So under Ruhan, you have to establish that the government has to establish the defendant knew that the prescription in this case he issued was unauthorized. I think that was a surprise. I think that was a novel decision. I think that the petitioners in that case going up were asking for a subjective good faith instruction. They weren't asking for that type of almost specific intent sort of standard that Ruhan got. In terms of the lower court decisions, the standard is near universal, not universal. I think that every circuit, save the 7th and the 9th, and including this one, had an objective standard. And again, it was always a good faith standard, an objective good faith standard. Even the 7th and the 9th had an objective good faith standard.
Let me ask you another question,
Yeah.
just preliminarily. Your client is currently on supervised release?
Yes, I believe so.
Okay.
He's still on supervised release? How come? I feel like the years don't work out right.
I'm going to be real honest, I haven't checked recently.
Okay.
I would have to look at it. If not, there are collateral consequences for him. Giving up if his medical license was partitioned on the plea, but I can't, I should have checked that, and I apologize.
Can I ask you a question? So is it your position that if a case falls within one of those 3 Reed categories, that's the end of the inquiry?
I
Because-
think it should be.
But is it?
You're right. I guess that probably brings me to the government's main point. And I can't deny this as a factual matter, if only because I was one of the people doing it. People were making this argument, right? Well, no one was really arguing what Ruhan held, so I think that is different. But people were arguing the good faith instruction should be subjective.
And not only that, but I guess the data point that seems most significant to me in considering whether the legal basis for this claim was available would be the Rahafe decision, which, you know, Ruhan then goes on to say, look, Ruhan, we came right out of Rahafe.
Yeah, I mean, I think that's, I guess the way I want to distinguish that is that, like I was talking about the Harrison Act cases, the good faith definition of medical practitioner was very ingrained, like centuries. It's not overturning like decades-long case law. It's overturning centuries-long case law that relied on good faith to define what medical practitioners, what's the difference between a guilty and a not guilty medical practitioner, right? You know, yes, I don't think it should be enough that just because there is some foundational constitutional principle that the court has recognized that any conceivable argument you make by that, or any conceivable way that they apply that, is definitionally not novel. You know, due process, well, yeah, but it's how it's applied, right? So I guess that's how I would say that Rahafe doesn't necessarily make this a non-novel argument, or make Ruhan a non-novel decision.
This might sort of circle back to your argument about Moore. I mean, the Supreme Court says in Ruhan, we are building directly on what we said in Rahafe. Like, how much, you know, just the way they say also, and we're not overruling Moore.
Mhm.
I mean, I'm trying to think about kind of what I have been recently reminded is the hierarchical nature of my relationship with the Supreme Court. And I'm trying to figure out how much am I bound by the way the Supreme Court sort of characterizes what it's doing in Ruhan.
I don't know that I am going to have a good answer to that question. In this case, I want to say, oh, don't worry about it. My position is not at all. But, you know, I understand that, the petitions in Ruhan cited Rahafe, right? It's not like that was ignored. But I do think it was more of, they're citing it for a very general principle. And the way it was cited, I can tell you, was we have to do something with these objective good faith instructions, because the good faith instructions without a subjective element, you know, don't distinguish culpable from non-culpable conduct. We didn't use that to say, at least as it was argued, it wasn't to say we need to attach a knowledge mens rea to the fact of authorization, right? And I think, you know, the Supreme Court took it that way, but I don't think that was the argument, if that makes sense. I have 1 minute left before my rebuttal time. It's my view that the government didn't actually contest the district court's finding on prejudice. I think the district court's finding on that was,
Murky.
well,
It
what?
said it was murky.
They said it was murky. I don't know if murky is a challenge. But I did want to say that if you read the sentencing transcript in the supplemental appendix, I think it's pretty obvious that everyone there was thinking about this in terms of a negligence or recklessness case. There's knew or should have known the, you know, the government said, I don't believe, the attorney for the government said, I don't believe it was ever his intent to just be there to hand out prescription pills to the victim. So I do think that there's ample, I think the district court was correct to find prejudice. And with that, I'm going to be into my rebuttal time, so unless there are any.
Before you do, I
Yeah.
want to be clear, at least in terms of the way I'm viewing this case. We talked about initially the three different methods, and you pointed to the third one.
I know, I didn't get
And then
there.
you proceeded with the first and second, which, you know, at least from my perspective, maybe you're moving me on those, but that third one seems, may have some teeth that we probably should address more. The question of whether Ruan disapproved of a practice that the Supreme Court arguably sanctioned in Moore. At least the Fourth Circuit thinks so, and at least Moore itself, there's language in there pretty strong on that. And,
Right.
and I'm just giving you my perspective for you to comment, but not just for comment. You say you want to come back on it, but because it seems this is the case, we can go round and round about this explicit, but that's, I mean, we already know it's not explicit. It did not explicit overrule it, and you know, you can talk about the different circuits, but these circuits have been all over the place on that second. It was fun to argue it, but it really is not, to me, it doesn't get to the heart of the case. Heart of the case, from my perspective, is in this third one here. And I thought you were going to walk right down that line and said, let me show you how Moore made everybody go this way, and the Supreme Court went somewhere different than Moore, which is explicitly one of the third things here. It seems like to me it favors you.
Right, I was trying to, I didn't bring it together enough. When I said that, you know, Moore is sanctioning this objective good faith language in the footnote, even if you want to say that Ruhan doesn't directly overturn Moore, you know, Moore lays out the test, Moore cites to the CFR 1306.04, Moore approves of the instructions that are similar to this one, and then the courts follow along with that, and based on that, you know, this court and the vast majority of other circuits says, yeah, Moore approves of this. And to that extent, that's why I think the third prong of the Ross sort of factors or circumstances apply. With that, I'd like to reserve the rest of my time.
Thank you. Ms. Niemeyer?
Good morning. May it please the court. Julie Niemeyer for the United States. This court should conclude that the scienter standard clarified in Ruan is not sufficiently novel to serve as cause to excuse the petitioner's procedural default. That's true for two reasons. The first is that the very concept of scienter is inherent in the concept of authorization. And authorization has been litigated for decades in terms of the good faith defense and the contours of that defense and what is required to prove it. And secondly, a scienter standard was essentially foreshadowed by other precedents, including Rehaef, which did exist at the time of the petitioner's plea. Starting with the first argument, the concept of—
Can I ask you a question about the Reed factors? I'm trying to figure out how the Reed factors fit in with your argument. Is your argument that it doesn't fall within one of the three Reed buckets, or is it that even if it does, you still have to add? Those are just sort of illustrative categories where a rule might be novel, but you always have to ask, was the legal basis available?
The government's position is that this case is not covered by any of the Reed categories. And I can explain with particular attention to the third category that Judge Wynn highlighted, changes that—
I think it's important, at least my perspective, and Judge Harris' question is going right to it, because I think it's right. We look at these factors, I mean, we can look at the first one, and yeah, you're going to argue, we know your argument on that. That's pretty clear. It doesn't explicitly say it. The question is there an implicit balance that gets it there? Difficult question to answer. The question of whether or not it's so pervasive in other circuits. Circuits have been all over the place for this thing, looks like to me. But that third one looks like it could have some teeth, as I indicated. I mean, it says, Ruan disapproved of a practice that the Supreme Court arguably sanctioned in Moore. And if you read Moore, it looks like there's a lot of language in there that points to that they are saying when they use language such as within accepted limits in the usual course of medical practice and exceeded the bounds of professional practice. And then the Fourth Circuit picks up this thing and reads it to implicitly approve of the objective approach. And then the Supreme Court comes with a subsequent case, looks to me like that fulfills disapproved of a practice that the Supreme Court arguably sanctioned in Moore. That's the direction I'm going in, and I'm giving it that. So again, this is one of those back judge went off of that misconception and because I have a different approach.
Well, Your Honor, let me address that directly.
Yes.
The instruction in Moore actually had two elements, and those are reflected in the modern-day CFR definition of what is authorized. It is authorized if the prescription is for a legitimate medical purpose and in the usual course of professional practice. Those two concepts were addressed in Moore in that instruction, because the instruction was that the physician did so other than in good faith for detoxification, which is a purpose for detoxification, in the usual course of a professional practice. So Moore could not be convicted under that instruction if he merely made an honest effort to prescribe for detoxification in compliance with existing standards. There was the legitimate medical purpose aspect to that. Was it for detoxification in that case? And the more objective, was it in the course of professional practice? Those two elements were inherent in the Moore decision, and we know that because different circuits interpreted Moore differently. So after Moore, the Ninth Circuit eventually held, first in the Hayes case and then in the Feingold case, that if a physician is acting outside of his authorization, by definition, he must be acting intentionally. Because if a practitioner deliberately acted outside the normal course of medical practice, there is inherently a scienter aspect to that.
But if the question is whether it was arguably a position that they did it, and you determine that the Fourth and the Fifth Circuit determined that Moore implicitly approved of an objective standard, doesn't that meet the arguably part? Even if you got other circuits that go a different way on it, even if you can read it, and maybe textually or however, but if you got two circuits that say this, sounds like to me that's an argument.
Well, Your Honor, I think it would be different if
Particularly
Moore...
this circuit.
Your Honor, if Moore had issued and then there were some circuit decisions and then there was another decision, possibly similar to Moore, building on Moore, that said very much the same thing and that sanctioned those prior circuit decisions. But that's not what we have here. There was a plurality of different decisions by the different circuits, and there was not a Supreme Court decision subsequent to that that sanctioned those.
You said plurality. I thought there was nearly unanimous agreement that the objective standard was the right test.
Well, Your Honor, there's two circuits, the Ninth and the Seventh, that have a clear scienter standard.
I'll give you those, but all the others went the other way, right?
Well, Your Honor, I think there are a few differences in the different circuits in terms of how they define good faith. Good faith, like as I mentioned earlier, has two components to it. It has the purpose component and the course of medical practice component. And there's been a lot of litigation about whether the objective test applies to just that course of medical practice component or also the good intentions, the purpose component. And we saw that here very recently in the Smithers case where the defendant asked for an instruction that split that test, that is one sentence in the CFR, into two separate prongs. That the defendant acted without a legitimate medical purpose or outside of the usual course of professional practice. And by making that a two-pronged, disjunctive proposed jury instruction, this court recognized that the defendant was trying to allow for a successful defense merely by one prong or the other prong. Perhaps the defendant acted with a legitimate medical purpose, or the defendant acted within the usual course of medical practice, objectively. And so recognizing that that first prong, legitimate medical purpose, has an intent element to it. It's not an intent requirement, of course, but it's in there. A purpose requirement, a legitimate medical purpose, has a scienter aspect to it. And so this court found that that was sufficient even to preserve the defendant's claim as to a mens rea argument, that claim wasn't waived because the defendant on appeal had raised an allegation of error as to the jury instructions, the good faith jury instructions. And because they'd asked for that disjunctive wording, the court held that that preserved the argument as to a subjective mens rea.
Counsel, what if, just assume for a minute that I think we might be in box 3 and box 2 of the Reed categories, and it's probably related, right? Everybody thought Moore said this, and that's why the circuits were more or less strong consensus to follow Moore and what everybody thought Moore meant. I don't think you've had a chance to come back to my first question, which was how do the 3 Reed buckets relate to the actual standard in this case? Is it the government's position that even if this case falls within one of those 3 Reed categories, you still prevail? Or do you think the question is it in one of those 3 categories? And if it is, then it's novel.
Your Honor, again, we would contend that this case doesn't fall into any of the 3 categories. But if this court were to find that it did fall into one of the categories and it did provide sufficient cause, our position is that...
I'm sorry, that's not my... So you are assuming that if it falls in one of the 3 Reed categories, it is novel, because I will just tell you that is not how I read Reed. I read Reed to be saying the question in every case is, was the legal basis for this claim reasonably available? Here are 3 examples where the answer is probably not, but not positive. Like you always have to come back to the question.
Agreed, Your Honor. Yes, absolutely. Yes. Even if there was an arguable case to be made for one of the categories in Reed, that would still need to be analyzed in terms of whether that claim was reasonably available to the petitioner at the time of his plea. And here, given the extensive case law arguing about these very concepts, whether or not any of those claims were successful in our circuit or in various other circuits, it was reasonably available as an argument. And as Judge Harris pointed out, that really is the question here. Was it reasonably available to the defendant at the time of his plea? And we can see that just, I mean, even in recent cases, it has been raised in a number of cases, unsuccessfully, but it has been raised, and so it was reasonably available. So the takeaway here is that scienter and the good faith instruction and the case law surrounding that, those are 2 sides of the same coin. And we've been debating that, of course, not in our circuit since Hurwitz, it's been clear, but in other circuits and in litigation over the wording of those specific instructions. Those are 2 sides of the same debate. The same evidence is relevant to prove either one. So we've been debating that for years. It was available to the petitioner. There was not a universal consensus. So moving forward from there, the cause element is not the only thing that the petitioner has to establish. The petitioner also has the burden of proving actual prejudice.
And do you feel that you preserve that by describing the prejudice issue as murky in your brief?
Your Honor, I do, because it's the defendant's burden. And Frady makes clear that that burden falls squarely on the petitioner, on the defendant. If the defendant has not made the case for actual prejudice, that as a factual matter...
It's just weird. I mean, if you mean the district court erred when it said there was prejudice, why doesn't the brief say that? Why does it say it's murky? I really didn't understand from your brief whether you were challenging this or not.
The government really wanted to address this mostly on the cause argument, and I believe that that was the thrust of the district court's decision, was based on cause. With respect to actual prejudice, this court is doing a de novo review. This court can reach any conclusion that it finds supported by the record. And here, the defendant hasn't met his burden of establishing that actual prejudice. And that's true because given the record here, given the facts, there is not a substantial likelihood that he would not have pled guilty even had he known of the Ruan standard. And that's true because there's circumstantial evidence throughout the record, abundant evidence from which the defendant, evaluating his chances in terms of going to trial or accepting a plea, would have concluded that the plea was in his best interests because this was a easily established case of knowledge of acting wrongfully without authorization.
I thought he said at sentence that he was trying to help Mr. Cohen with his addiction. If that's the case, why would an instruction that your subjective intentions would be something we'll have to deal with here, as opposed to the objective standard?
Yes, Your Honor, yes, that's definitely addressed by the first phrase of the existing good faith instruction, which is that if the defendant acted in good faith that this was a legitimate medical purpose, right, in an honest way, an honest purpose, that would be relevant for the jury to consider. But Ruan very clearly established that an unreasonable but subjective belief that one was acting for a legitimate purpose and within the usual course of medical practice wasn't enough, because the court said that knowledge can be shown by circumstantial evidence, that the scope of authority remains tethered to objective criteria, and that the more unreasonable a defendant's asserted beliefs or misunderstandings are, especially as measured against objective criteria, the more likely the jury will find that the government has carried its burden of proving knowledge. And so with that language, the Supreme Court, even though it's changing the scienter standard, has essentially telegraphed that the objective criteria are still very important. A subjective belief that one is acting lawfully and with a legitimate purpose isn't enough if the objective criteria say otherwise. And there's sort of a sliding analysis there. The more unreasonable that belief was measured against objective criteria, then the more likely it is that a jury would find that the defendant did in fact have knowledge.
I mean, I totally understand what your argument would have looked like in front of a jury. You know, this is so idiosyncratic, and you're allowed to look at objective criteria, and come on, no one really would have thought this. And, you know, maybe, who knows, probably likely to prevail, but that's not quite the question, right? Like, he had a case to make to a jury in a way that sometimes, you know, like when it's, did you know you were a felon or not, and you spent 10 years in prison, you really, what are you gonna tell a jury? But here, like, this guy has a case to make, right? Yes, I knew he was using street drugs, but if I stopped prescribing this, he would just use them more. He's got both an addiction and a genuine pain problem. Like, I'm doing the best I can here. Like, it doesn't strike me as wholly out of the question that he might have wanted to take that to a jury.
Well, yes, Your Honor, and I have two thoughts to offer in response to that. The first is that I think it's important to remember that the chance that he would have taken it to a jury wouldn't be enough. Even a reasonable likelihood that he would have taken it to a jury wouldn't be enough. It has to be a substantial likelihood that he would not have pled guilty. And then the second thing I would like to offer is that there was significant evidence available at the time of the plea in the form of the expert opinion of Dr. Kennedy that this was far outside the normal course of medical practice. Well outside the normal course of practice, that's at SA 9. It was without rationale, was another one of Dr. Kennedy's conclusions, and that he was not surprised that a fatal result was the outcome.
Well, a jury could have rejected that evidence, though, right?
It could have, yes, but have we established a showing of a substantial likelihood that the petitioner would not have pled guilty. And another aspect of this that we'd have to take into consideration is the practical issues involved in the defendant's plea.
Can I just ask you a question? And I'm embarrassed. I don't quite remember the procedural posture of this case. Was there ever a hearing on this? Like, is there a factual record about the circumstances under which he took the plea? Was he eager to take the plea? Was he wavering? Like, do we know any of that?
Your Honor, this was a plea to an information as part of a negotiated plea agreement. There was a factual basis detailing the evidence in the case. He pled to 6 counts presented in an information in exchange for a waiver of his right to an indictment. Part of the plea agreement was that the government agreed to limit the attributable drug quantity for the defendant. That was a very important part of the agreement because the government was then limited in its the guidelines range that the defendant would face. The amount that was attributed to the defendant by this negotiated agreement was only the amounts that were prescribed on the 6 dates that Mr. Cohen also tested positive for street drugs. Only those drug amounts were counted. And so that limited the defendant's sentencing exposure to a much lower range than it would have otherwise been. So that has to be considered as part of the analysis of whether the defendant would have pled guilty. We have taken that chance of facing a much higher guidelines range because as properly applied, as the PSR reflects following standard procedures of the guidelines attributable drug quantity, he was attributed with a much higher quantity that would have resulted in a much higher sentencing range. So by accepting this negotiated plea, he placed a cap on that range that was very beneficial to him. And the reasoning behind that is apparent in the sentencing record as well. Because when the judge said, hey, the PSR says that the attributable drug quantity is X, why are both of you coming to me and saying that it's Y? And in response to that, the defendant argued, well, because he should only be attributed, and we agreed that he should only be attributed the drug quantities that were distributed on the dates he tested positive. Even though the evidence showed that the defendant knew that the prescriptions were without medical purpose when he returned to prescribing oxycodone to Mr. Cohen after trying a period of Suboxone because he knew that he was an addict. He found out he was an addict in August of 2014 because the victim admitted it to him directly, and then there was a period of trying Suboxone, trying to get him off those drugs, and then January of 2015, he returns to prescribing oxycodone with no legitimate medical purpose. And he does so for the next 18 months. That was a much broader course of conduct than simply the 6 acts of distribution that occurred in 2016 on the dates of the positive drug tests. Your Honor, I see my time has expired. If there are no further questions,
Thank you very much.
the government submits. Thank you.
Thank you. I guess I want to say he did have a lot to work with. After Ruhan, that is, if he were to go to trial. You know, as to Dr. Kennedy, what Dr. Kennedy can testify to is that Dr. Dimpka's medical records didn't, you know, contain enough information for Dr. Kennedy to identify a legitimate medical purpose. And Dr. Kennedy can say that keeping appropriate medical records is within the usual course of, is necessary to stay within the usual course of professional practice. But he can't say that petitioner didn't do tests. He can't say that petitioner didn't do a physical examination. He can't say what actually occurred in that room. That's about as far as an expert can go in this case. In addition, there are some very good facts here for petitioner. You know, he referred Mr. Cohen to a therapist. He tried to refer him to long-term pain treatment. He has gotten other people successfully off of being addicted to heroin and cocaine in his practice before. The government, at sentencing, admitted, this is not a pill mill. It's this specific guy that was charged, right? Or the specific victim in this case was the only charges. And again, the government sentencing admitted that the majority of his practice was entirely legitimate, right? So with that, when intent, and it is intent, it's not what he reasonably should have believed. Nothing in Ruhan says has anything to do with reasonable. It's a straight up knowledge intent argument. In terms of what he actually believed and what a jury would find, I think the fact that he had absolutely no motive to do anything wrong in this case might matter.
Counsel, for all of that, though, you're not making an actual innocence
I am
argument,
not.
right?
I think
Okay.
the standard is too hard to push.
Okay.
But honestly, I think if this were a direct appeal and it were a plain error case, I would walk away with the win. The other thing I wanted to point out in terms of Ruhan really quickly, counsel quoted you could still rely on objective facts to establish intent. Well, sure, that's true, right? Of course that's true. That's how you establish a person's mental state if they're not going to testify or confess. But the very next sentence the Supreme Court wrote after the paragraph she quoted is, but for the purpose of 841 as charged against medical practitioners, the government still must prove that the defendant knew or intended the prescription be unauthorized. I didn't actually, that's very close to a direct quote, and I'm sure I quoted it in our brief. So this is, I really think it is incredibly unlikely that if this particular doctor was told that the government has to prove that he believed at the time that he was writing these prescriptions, that writing those prescriptions was wrong, that it was outside of his authorization, I think he would never have pled guilty.
Well, maybe in the abstract, but in the context of the offer that was made to him, do we take that into account?
I think it's fair to take it into account. I would say that there was a contest over the drug amount at sentencing between the government and the defense. The defense wanted just the 6 days, and the government wanted either after the meeting with the brother, everything after the meeting with the brother, or everything after the first drug test. I can't remember which one, but there was a disagreement, albeit in all honesty, not one that impacted the guidelines range.
But there's never been an evidentiary hearing on this question, right? I feel like usually when this comes up, there's an evidentiary hearing, and the lawyer's like, oh, no, he was dead set on pleading guilty, nothing would have changed that, or vice versa. Yes,
Right.
he was
Well,
on a knife's edge, and...
The reason that it's weird is because I can't do an IAC here, right? I
Okay,
can't
so
do it.
that's why
That's why
gotcha.
it's it.
Okay.
I can't do an IAC here, so
So we have to do it without, like, a factual record.
Right,
We
I-
just have to imagine. Okay.
yeah. And like I said, I don't know if this is an appropriate consideration, but he is here asking for his conviction to be vacated, and he's on supervised release. Like, I think clearly Ruhan is the thing that impacted that choice, right? So with that, unless there are any other questions,
Thank you very much, counsel.
rest in the brief. Thank you.
We appreciate the arguments of both counsel. We'll come down and greet you and adjourn for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Oh, you're right, we have an argument this afternoon.
I did a Zoom with the Fourth Circuit during COVID. Nice to see you, Jim.
name's Kirsten. Nice to meet you. Sorry, I couldn't remember if I said it earlier, but I definitely probably did not. So. Oh, nice to meet you. Nice to meet you. Yeah, I'm trying to get my mind back in. Okay, here we go. It's starting again. Absolutely. I can ask our calendar clerk if she has something. Yes, some of them are in chambers. So, red, blue.
Write this down as you talk.
And then, gold is across from a chambers, but it's still connected to the courtroom.
Okay, but it's like a separate entrance.
Yeah, so like
Okay.
gold, you're standing there and you're looking at the bench. The roping room is to the left. So like if you're walking into the courtroom down the hallway, it's, I believe, the last door on the right. But I will talk to Naima when I get back in 10 minutes and ask if she has something she can send out to you all.
Yeah, that'd be
Just
terrific.
so-
Just because we covered the courts on our tour yesterday, but not specifically our entrance to the roping room
Yes.
to take
Yeah,
judge. and
so
things
yeah,
like that.
definitely would not be through the courtroom.